We've had multiple noise complaints from this address.
That's not possible. My home has been quiet.
Ma'am, don't argue with me. This address was reported.
Who made the complaint?
That information is none of your business.
You do not have permission
Step back right now. You're being uncooperative.
This is my house.
Ma'am, please just stay calm. Let's keep it simple.
Ma'am, I need you to step outside. Now. The voice carried that particular blend of impatience and certainty that comes from years of unquestioned compliance. Officer Derek Millhouse stood on the front porch, one hand resting on his belt, the other holding a flashlight, though it was barely past 7 in the evening. The woman in the doorway didn't move. She wore reading glasses and a cardigan. Her expression was flat, measuring. "This is my home," she said quietly. "You're going to need to explain what you're doing here." Millhouse's jaw tightened. "We received a call about a disturbance at this address. I need to verify who lives here." "There's been no disturbance. That's not for you to determine." His tone sharpened. "Now I can do this the easy way or the hard way, but you are going to comply." She tilted her head slightly, as if examining something under glass. "Officer, do you have probable cause for this contact? Or are you conducting a warrantless threshold interrogation without articulable suspicion of criminal activity?" The question hung in the air. Millhouse's partner, a younger officer named Valdez, shifted his weight on the steps behind him. The porch light cast long shadows across the brick walkway. Millhouse took a half-step forward. "I don't care what you think you know about the law. You can answer my questions here, or we can continue this conversation downtown." The woman's hands remained at her sides. "I see," she said. It was October 12, 2019. The address was a quiet residential street in Clayton, Missouri, a suburb west of St. Louis known for its tree-lined blocks, carefully maintained lawns, and the kind of neighborhood watch groups that prided themselves on vigilance. Officer Derek Millhouse had been with the Clayton Police Department for 11 years. He'd worked his way up from traffic patrol to a street crimes unit that specialized in what the department called proactive community engagement. His personnel file included 3 commendations for felony arrests and 2 formal complaints, both dismissed after internal review. His reputation among fellow officers was solid. He knew how to handle himself. He didn't hesitate. Command staff liked that about him. He closed cases and didn't flinch when situations got physical. But there were whispers. In 2016, a defense attorney had filed a motion to suppress evidence in a drug case, citing Millhouse's pattern of what the filing called pretextual stops in majority-minority neighborhoods. The motion was denied. The case settled. In 2018, a community activist group submitted a complaint about Millhouse's involvement in 4 separate incidents where Black residents reported being stopped near their own homes and asked to prove they lived there. The department's Internal Affairs Division reviewed the matter and found no policy violations. The file was marked closed. Millhouse didn't consider himself biased. He considered himself experienced. He knew what didn't fit. He trusted his instincts. On this particular evening, dispatch had received a call from a neighbor, a Mrs. Patricia Hendricks, 3 houses down, reporting suspicious activity at 4782 Wrenwood Lane. The caller said she'd seen someone unfamiliar entering the residence and was concerned because the neighborhood's been changing. Dispatch coded it as a welfare check. Millhouse and Valdez took the call. Routine. They'd done 100 of these. When they arrived at the address, the lights were on inside. The front door was closed. A silver Lexus sedan sat in the driveway, its hood still warm. Millhouse walked up the front steps and knocked. Firm. Official. The woman who answered was black, mid-50s, average height. She wore slacks and a cream-colored cardigan over a collared shirt. No jewelry except a watch. Her hair was pulled back. She looked like a schoolteacher, maybe, or an office manager. She didn't look like she belonged in this neighborhood, not to Millhouse's eyes. That instinct, that flicker of mismatch was enough. He began asking questions. She began answering calmly with the kind of specificity that made Millhouse more irritated, not less. What he didn't notice in those first 30 seconds was the way her eyes tracked every movement he made, the way she noted the position of his hands, the way she registered Valdez's body cam light, a small red dot blinking just below his collar. She wasn't nervous. She was documenting. Her name was Judge Rosalind Carter. Not a traffic court judge. Not a magistrate handling misdemeanors. She was a United States District Court judge for the Eastern District of Missouri, a lifetime appointment made 4 years earlier after a distinguished career as a federal prosecutor and civil rights attorney. She had clerked for a Supreme Court justice. She had argued cases before appellate panels across the country. Her rulings were cited in law school textbooks. But on her own front porch on a Saturday evening, none of that was visible. To Officer Millhouse, she was simply a black woman in a wealthy white neighborhood who wasn't answering questions the way he expected. Judge Carter had been home less than 20 minutes. She'd spent the day at her chambers downtown, reviewing briefs for an upcoming civil rights case. Ironically, a Section 1983 suit involving allegations of excessive force by a municipal police department in southern Illinois. She'd driven home, parked in her driveway, and carried in 2 bags of groceries and a leather briefcase stuffed with case files. She'd changed out of her court attire into something comfortable, made a cup of tea, and settled into her reading chair near the front window. That's when the knock came. Sharp, authoritative, repeating. When she opened the door and saw 2 uniformed officers, her first thought was procedural. What's the basis for contact? Her second thought was weary recognition. She'd seen this before, not to herself but to others. To her brother once in Atlanta, to a colleague's son in Chicago, to clients she'd represented decades ago. The assumption of wrongness, the burden of proof placed on the person who'd done nothing wrong. She knew what was happening, but she also knew the rules. She knew the Constitution. And she knew that the moment she revealed her identity too early, the encounter would end, and the lesson wouldn't land. So she answered Millhouse's questions with precision, but no deference. This is my home. I've lived here for 3 years. No, I don't have to provide identification when I'm standing in my own doorway. Each answer was calm, clinical, accurate. Each answer made Millhouse more suspicious, because in his experience, innocent people cooperated immediately. Innocent people didn't cite constitutional standards. Innocent people didn't ask him to justify his presence. "You're being awfully defensive," Millhouse said. "Makes me wonder what you're hiding." Judge Carter folded her arms, not aggressively, just economically. "Officer, I'm not being defensive. I'm exercising my Fourth Amendment right to be free from unreasonable searches and seizures. You've initiated contact at my home without a warrant and without exigent circumstances. Unless you have articulable, individualized suspicion of criminal activity, this is an unlawful detention." Valdez, the younger officer, glanced at Millhouse. Millhouse's face hardened. "You're one of those." "I'm one of what?" "A legal expert," he said, voice dripping sarcasm. "Probably watched some YouTube videos. Think you know the law better than I do." She didn't rise to it. "I'm simply asking you to follow the law. And I'm simply asking you to prove you live here. It's not complicated." "Actually, officer, it is. Because the burden of proof in this interaction isn't on me. It's on you. You're the one making the claim. You're the one exercising state authority. I'm under no legal obligation to prove my residence to satisfy your curiosity." The words were textbook perfect. They were also infuriating to a man who'd spent 11 years having people comply the moment he asked. Millhouse took another step forward, close enough now that he was technically past the threshold. His boot on the interior side of the doorframe. "Step outside," he repeated. "I'm not going to ask again." Judge Carter's eyes dropped to his boot, then back to his face. "You just performed an unlawful entry into my home," she said quietly. "Without consent, without a warrant, without exigent circumstances." Valdez's hand moved toward his own body camera, as if checking it was still recording. Millhouse didn't notice. He was too focused on the woman in front of him, this problem who refused to be intimidated, who refused to comply, who somehow thought she could lecture him about the law. "Last chance," he said. Judge Carter reached slowly into her cardigan pocket. Millhouse's hand dropped to his holster. "I'm retrieving my phone," she said evenly, movements deliberate and visible. "I'm going to call your supervisor." Put the phone down. Millhouse's voice had lost its professional veneer entirely now. It was flat, commanding, the tone of someone who expected immediate obedience. Judge Carter's thumb hovered over the screen. I have the right to record this interaction and to contact. I said put it down. His hand remained on his holster. You're reaching into your pockets, refusing to comply with a lawful order, and now you're creating a disturbance. That's obstruction. The air had changed. What began as a welfare check had curdled into something else entirely. A confrontation fueled by ego and assumption, spiraling beyond any reasonable response to the initial call. Valdez shifted his weight behind Millhouse, his young face uncertain. The body camera on his chest captured everything. The angle of Millhouse's stance, the woman's careful movements, the residential street behind them still and quiet except for the distant hum of a lawnmower 2 houses down. Judge Carter lowered the phone but didn't pocket it. Officer, I'm going to say this clearly. You have no legal basis to order me out of my home. You have no warrant. You have no exigent circumstances. You have no probable cause. What you're doing right now is a Fourth Amendment violation, and every second you continue, you're compounding your civil liability. Millhouse's jaw clenched. The porch light above them flickered once. A dying bulb, casting unstable shadows across the brick. Civil liability, he repeated mockingly. You people always have an excuse. Always know your rights until you're sitting in the back of my car. He turned slightly toward Valdez. Get ready to call for backup if she resists. Resists what exactly? Judge Carter's voice remained level, but something in her posture had shifted. A courtroom readiness. The stance of someone who'd cross-examined hostile witnesses for decades. You haven't articulated a crime. You haven't identified a legitimate law enforcement purpose. You're conducting what amounts to an investigatory detention based solely on... She paused, letting the silence do the work. Your subjective impression that I don't belong here. The words landed precisely. Millhouse's face flushed. I don't care who you think you are or what you think you know. We got a call. We're investigating. And you're going to cooperate, or I'm going to arrest you for obstruction and interfering with a police investigation. Interfering with what investigation? Her tone was surgical. Please describe, in detail, what crime you're investigating at this moment. Suspicious activity. That's not a crime. Trespassing. I live here. Prove it. The circular logic was stunning in its transparency. He needed her to prove residency to justify his presence, but his presence was supposedly justified by investigating her residency. It was a catch-22 built on sand, and Judge Carter recognized it instantly as the kind of pretextual enforcement she'd seen dismantled in 100 federal cases. She also recognized something else. Millhouse wasn't going to back down. His authority had been challenged, and in his world, that meant escalation was the only response. Officer Millhouse, she said, reading his nameplate carefully. I'm going to step back inside my home now. If you wish to continue this interaction, you may leave your card, and I'll contact the department directly to file a formal. You're not going anywhere. Millhouse moved fully into the doorway now, his boot wedging the door open. Behind him, Valdez's camera captured the clear threshold violation. The unauthorized entry into a private residence. The physical prevention of a homeowner from closing her own door. The smell of the evening air mixed with something else now. Millhouse's cologne, sharp and cheap, and beneath it the faint scent of stale coffee on his breath. Judge Carter could feel the temperature differential between the cool October air outside and the warmth of her home's interior. Her wrist ached slightly where she'd held the phone, tension radiating up her forearm. You're now unlawfully detaining me in my own home, she said. And you've entered without consent, without a warrant, without exigent circumstances, and without probable cause. Every element of your conduct in the last 3 minutes constitutes a violation under Peyton v. New York and a clear Section 1983 civil rights violation. Millhouse's eyes narrowed. Keep talking and see what happens. I'm documenting your threat of retaliation for exercising constitutional rights. That's another violation. You think you're smart? Millhouse's voice rose now, the professional mask fully gone. You think because you can quote some case names, you're going to, what? Sue me? Good luck. The department's got lawyers. The union's got lawyers. And you know what they're going to say? That you were uncooperative, aggressive, and refused to identify yourself during a legitimate investigation. It was a well-worn script, the institutional machinery already preparing its defense before the violation was even complete. But Millhouse had made a critical error. He assumed she didn't know how that machinery worked. He assumed she'd be afraid of it. Judge Carter's expression didn't change. Officer, I want you to listen very carefully. In the last 4 minutes, you have committed the following policy violations. I don't need a lecture from unlawful entry into a residence under color of law, she continued, voice cutting through his interruption with the precision of a scalpel. Investigatory detention without reasonable suspicion. Threatened arrest in retaliation for exercising First Amendment rights. Failure to de-escalate. Failure to identify the legal basis for contact when requested. Valdez had gone very still. His hand hovered near his radio. Millhouse laughed. A short, bitter sound. You done? No. Judge Carter shifted her weight slightly, her shoulder now angled toward the interior of her home where, visible in the hallway behind her, a framed photograph hung on the wall. It showed her in formal robes, standing in what was clearly a federal courtroom, shaking hands with a senator during her confirmation ceremony. Millhouse didn't notice it. He was too focused on her face, too locked into the confrontation he'd created. Here's what's going to happen, he said, his voice low and threatening. You're going to produce identification right now. Driver's license, utility bill, mortgage statement, I don't care. Or I'm going to detain you. Search this property for proof of residency. And if I find out you're lying, you're going to jail for false reporting and obstruction. And if I produce identification? Judge Carter asked. What's your legal authority to demand it in the first place? Because I'm a police officer conducting an investigation. That's not a legal standard, officer. That's an assertion of authority without constitutional basis. The fluorescent porch light flickered again, casting the scene in stuttering illumination. Millhouse's hand still near his weapon, Valdez's body camera recording in silent judgment, Judge Carter standing in her own doorway like a defendant at trial. Somewhere down the street, a dog barked, car door closed. Normal suburban sounds that felt grotesquely out of place beside this manufactured crisis. Millhouse reached for his radio. Dispatch, this is Unit 12. I need a supervisor to my location. Uncooperative subject refusing to identify. Possible 10 to 15. 10 to 15. Civil disturbance. Judge Carter's eyes tracked the radio call, her mind already calculating the cascade that was coming. The supervisor who'd arrive, the report that would be written, the narrative that would be constructed. She'd seen it before in case files. The retroactive justification, the careful wording designed to transform unlawful conduct into reasonable police work. But this time there would be video. There would be witnesses. There would be a record even the best police union attorney couldn't spin away. Officer, she said quietly, you're going to want to step back now. I'm not going anywhere. Then you're making a choice, she said. And that choice is going to follow you for the rest of your career. Millhouse smirked. Is that a threat? No, Judge Carter said. It's a fact. The supervisor arrived 6 minutes later. Sergeant Linda Kowalski was a 22-year veteran, a training officer who'd worked in internal affairs and knew the department's exposure points better than anyone on the force. She pulled up in her marked unit, assessed the scene from the street, and felt her stomach drop. Millhouse was still in the doorway. The homeowner, a middle-aged black woman, stood with her arms crossed, phone in hand, expression unervingly calm. Kowalski had been around long enough to recognize a disaster before it fully unfolded. Millhouse, what's going on? She called from the walkway. Uncooperative subject, Sarge. Refusing to identify. Welfare check turned into a possible trespass situation. Kowalski walked up the steps slowly, her eyes scanning the scene. The woman's clothing. The house behind her. Expensive furnishings visible through the doorway. Bookshelves packed with legal volumes. Framed credentials on the walls. And then Kowalski saw it. The photograph in the hallway. The federal robes. The formal setting. Her heart stopped. "Millhouse," she said quietly, urgently. "Step back. Sarge, she won't. Step back. Now." Something in Kowalski's voice penetrated. Millhouse hesitated, then moved half a step backward, confusion crossing his face. Kowalski turned to the woman, recognition flooding through her with the cold clarity of professional catastrophe. "Judge Carter," she said. It wasn't a question. Judge Carter nodded once. "Sergeant." The word hung in the October air like a verdict. Millhouse's face went blank. "What?" "This is Judge Rosalind Carter," Kowalski said, her voice carefully controlled. Each word weighted with the knowledge of what had just occurred. "United States District Court. Eastern District of Missouri." The silence that followed was total. Valdez's hand had frozen on his radio. His body camera continued recording, capturing Millhouse's face as the realization hit, the color draining from his features, his hand dropping away from his belt as if the holster had suddenly become radioactive. "Judge Carter," Kowalski continued, turning fully toward her now, "I apologize for this incident. We'll be leaving immediately, and I'll be filing a full report with the chief and initiating an internal review of—" "Sergeant," Judge Carter interrupted, her voice still calm but carrying a new weight now, the authority of someone who just allowed a rope to be woven and was now watching it tighten. "I'm not interested in apologies at this moment. What I need is for you to document, in writing, every action your officers took from the moment they arrived at my door. Every statement, every threat, every constitutional violation." "Yes, ma'am. And I need you to preserve all body camera footage immediately. Do not allow it to be reviewed, edited, or cleared under any retention policy. That footage is now evidence in a federal civil rights matter." Kowalski's face had gone pale. "Understood." Millhouse finally found his voice. "Judge, I didn't know. I mean, if I'd known." Judge Carter's eyes moved to him. The look was colder than any judicial rebuke from the bench. "Officer Millhouse," she said quietly, "the law applies the same whether you know who I am or not. That's the point you just failed to understand." She stepped back and closed her door. The click of the lock was the loudest sound on the street. The body camera footage reached the city attorney's office at 9:47 a.m. on Monday morning. David Brennan had been Clayton's lead counsel for 6 years. He defended the city against slip-and-fall claims, employment disputes, and the occasional excessive force complaint. He knew how to manage risk. He knew how to negotiate settlements that protected the municipality's insurance rates. But when he pressed play on the video file marked "Urgent Carter Incident," his coffee cup stopped halfway to his lips. He watched Millhouse's initial contact, the dismissive tone, the escalation. He watched the threshold violation, Millhouse's boot clearly crossing into the residence without consent. He watched the threats, the demands for identification, the assertion of authority without legal basis. And then he watched the reveal. The moment Sergeant Kowalski said the name Judge Carter, Brennan's hand moved to his phone. He didn't wait for the video to finish. He dialed the city manager directly. "We have a problem," he said. That was an understatement. By Tuesday afternoon, Brennan had pulled Judge Carter's record. He sat in his office, surrounded by case law printouts and personnel files, experiencing what lawyers privately call the sinking feeling. That visceral recognition that you're holding a losing hand with no way to bluff. Judge Rosalind Carter wasn't just any federal judge. She was a former civil rights prosecutor who'd spent 15 years litigating Section 1983 cases, police misconduct, qualified immunity, municipal liability. She'd written a law review article on pretextual stops. She'd delivered speeches on racial profiling at DOJ conferences. And they'd sent 2 officers to demand identification at her own front door. The legal term for what Brennan felt in that moment was indefensible exposure. The city's insurance carrier reached the same conclusion within 48 hours. Their risk assessment was brutally simple. Body camera footage showing clear constitutional violations performed against a federal judge who literally taught seminars on these exact violations. with documentation of prior complaints against the same officer showing a pattern of racially biased enforcement. "We can't win this," the insurance adjuster told Brennan over the phone. "We can't even survive discovery. The moment this goes to trial, every case Millhouse ever touched gets reopened. Every stop, every arrest. Defense attorneys across the state will be filing appeals." Brennan knew she was right, but it got worse. Judge Carter didn't file a lawsuit immediately. Instead, her attorney, a prominent civil rights firm out of St. Louis, sent a preservation letter to the department, the city, and the insurance carrier. It was 12 pages long and read like a prosecution memo. It detailed 23 separate constitutional violations across a 4-minute interaction. It cited 16 cases directly on point, including 3 that Judge Carter herself had ruled on from the bench. It noted that Officer Millhouse's personnel file contained 2 prior complaints for racially discriminatory enforcement, both dismissed without meaningful investigation. And then, almost as an afterthought, it mentioned that Judge Carter had been in the middle of writing an opinion in a Section 1983 case involving similar fact patterns when the incident occurred. The irony, the letter noted, was not lost on anyone. The city manager called an emergency session with the police chief, Brennan, and the insurance company's lead attorney. The meeting lasted 11 minutes. "How much?" the city manager asked. Brennan had already run the numbers. "If this goes to trial, we're looking at compensatory damages, punitive damages, attorney's fees, and injunctive relief requiring department-wide policy reform. Conservative estimate? 1.2 million. Worst case? North of 3 million, plus the cost of a federal consent decree." The insurance attorney nodded grimly. "And that's assuming we don't lose qualified immunity for Millhouse, which we will, because the law was clearly established. Which means personal liability. Which means he declares bankruptcy, and the carrier gets hit with the full judgment." "Settlement range?" the city manager asked. "600 minimum," Brennan said. "Probably closer to 750 once we factor in attorney's fees and the PR cost of this going public." The room went silent. Someone asked the obvious question, "Can we fight it?" Brennan pulled up the body camera footage on the conference room screen. He let it play, Millhouse's voice dripping with condescension, the unlawful entry, the threats, the final moment when reality crashed down. "That's what a jury sees," Brennan said. "A federal judge, in her own home, being treated like a criminal by an officer with prior complaints. While cameras roll, we don't have a defense. We have a catastrophe." Internal Affairs launched an investigation, but everyone knew it was performative. The findings were predetermined by the video evidence. Officer Derek Millhouse was placed on administrative leave within 72 hours. By the end of the month, the department had offered him a choice: resign or face termination proceedings that would be public, ugly, and career-ending. He resigned, but resignation wasn't enough to shield him from the fallout. The FBI's Civil Rights Division opened a preliminary inquiry into whether Millhouse's conduct rose to the level of criminal deprivation of rights under color of law, Title 18, Section 242. The standard was high, willful violation of constitutional rights. But the video evidence, combined with the pattern of prior complaints, gave federal prosecutors something to work with. 6 months later, Millhouse was indicted on 2 counts: deprivation of rights under color of law and making false statements to federal investigators during the inquiry. The trial lasted 4 days. The jury deliberated for 90 minutes. Guilty on both counts. Sentencing came 3 months after that. 8 years in federal prison with credit for time served. The settlement with Judge Carter was finalized quietly, sealed by mutual agreement. The number never became public, but courthouse sources familiar with the matter confirmed it was north of $675,000, paid by the city's insurance carrier, with the city responsible for a $50,000 deductible. Judge Carter donated the entire amount to a legal defense fund for low-income residents facing civil rights violations. She never spoke publicly about the incident. She didn't need to. The system had spoken for her. Here's what makes this story different from 1,000 others like it. Judge Carter had resources. She had knowledge. She had institutional power. She knew exactly which words to use, which violations to document, and how to preserve evidence that would survive any attempt to bury it. But strip away the title, the robe, the federal appointment, and the story becomes disturbingly familiar. How many others have stood in their own doorways, faced the same assumptions, heard the same threats, and had no recourse? How many had no camera, no witness, no legal training to articulate what was happening to them in real time? The Clayton Police Department implemented new training after the incident. Officers now receive instruction on implicit bias, de-escalation, and the constitutional limits of welfare checks. The policy changes are real, but they're also reactive band-aids applied after the wound was exposed. The deeper question remains unanswered. What systemic assumptions allow an officer to look at a woman in her own home and see a threat instead of a resident? What institutional culture permits prior complaints to be dismissed, patterns to be ignored, and escalation to be rewarded? Officer Millhouse didn't wake up that morning planning to violate someone's civil rights. He walked up to that door with 11 years of experience telling him his instincts were correct. He'd done this 100 times before. He'd made assumptions, demanded compliance, and walked away with commendations. The only difference this time was that his target had the power to fight back. And that's the haunting part. The system didn't protect Judge Carter because it values civil rights. It protected her because she was too powerful to ignore. She had the knowledge to name the violations as they occurred. She had the credentials to make the department's defense collapse on contact. But justice shouldn't require a law degree and a lifetime appointment. It shouldn't require knowing the precise language of Terry versus Ohio and Peyton v. New York to avoid being arrested in your own home. The Constitution applies the same to everyone, in theory. In practice, enforcement depends on who you are, what you know, and whether the system fears you more than it dismisses you. Judge Carter proved that documentation, knowledge, and composure can dismantle even the most arrogant abuse of authority. But she also proved something darker. That the system bends only when it has no other choice. So here's the question this story leaves behind. If it takes a federal judge to hold one officer accountable for a 4-minute interaction, if it requires that level of power, knowledge, and resources to achieve something resembling justice, what happens to everyone else? What happens when the door closes, the camera's off, and the person standing there doesn't know the law well enough to stop what's coming? The answer is uncomfortable, and it's still happening. If this story made you think, consider subscribing. There are more stories like this that need to be told.